Judiciary Committee will come to order. And committee, we do have on the agenda today to hear a bill. However, we have several bills that we have previously heard. And since we have only today and tomorrow to work any bills that we have heard, I'd like to address those first. So with that then, if you will refer to Senate Bill 493, requiring ignition interlock device manufacturers to pay fees to the state for the administration of the ignition interlock program. I think we heard that last week. And again, that's Senate Bill 493. If you'll pull up your folder, and we'll ask for just a brief from the reviser.
Yikes.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So SB 493 you heard on the 15th, and that is the bill brought to you by the Highway Patrol that would put a new fee on ignition interlock device manufacturers. There would be both a one-time fee each time they install a device in our state and a monthly fee whenever they do maintenance and other monitoring of the device each month for folks in Kansas.
Thank you, committee. Are there any questions for the reviser? Not seeing any. Is there any discussion, or I would entertain a motion? Senator Wilborn.
Thank you, Madam Chair. I move that I'd like to move 493 out, favorable for passage.
Thank you. Is there a second? Senator Bowers. Thank you. Committee, you all have heard the motion. Any discussion? And then you all again have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, same sign. The motion carries. Next, let's turn our attention to Senate Bill 420, another bill brought to us by law enforcement. And it is eliminating the element of concealment from the crime of breach of privacy related to installing or using a device to photograph or record another identifiable person under or through the clothing being worn by that other person. And with that, again, that's Senate Bill 420 and a brief from the reviser.
Thank you again, Madam Chair. This is Jason Thompson again. So this SB 420 you heard the same day, the 15th, is brought to you by the County and District Attorneys Association, and it removes two words in current law. The current law is a concealed camcorder or device to secretly videotape, film, or photograph someone. So it removes the words concealed and secretly, but otherwise maintains current law.
Thank you. Committee, any questions for the reviser? Is there any discussion or a motion? Senator Baumgardner.
Thank you, Madam Chair. I move that we pass out Senate Bill 420 favorably for passage.
Thank you. Is there a second? Senator Gossage. Thank you. You all have heard the motion. Any discussion? Not seeing any. Then you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, same sign. The motion carries. Thank you. And then next we will turn our attention to, again, another law enforcement bill brought to us, Senate Bill 381, authorizing the Board of County Commissioners of any county that is not the most populous county in a multi-county judicial district to appoint a coroner to serve as the district coroner for the county at the expense of the county. And with that, then, a brief from the reviser.
Thank you again, Madam Chair. Jason Thompson one more time. SB 381 brought to you by the Law Enforcement Associations, represented by Mr. Klump, as I recall. This is the current coroner process in single county judicial districts. The Board of County Commissioners appoints that district coroner. In multi-county judicial districts, which Kansas has several of, the most populous county appoints the coroner for that judicial district. This would allow an alternative option for one of the not most populous counties to appoint their own district coroner for their county specifically at their own expense. And the district coroner for the rest of the district would serve the other counties. The one for that particular county would serve that particular county.
Thank you. Committee, any questions for the revisor? Senator Olson.
I'm ready to make a motion when you're needed.
Okay. Any questions for the revisor? Not seeing any, then Senator Olson has a motion.
Thank you, Madam Chair. Pass out Senate Bill 381 favorable for passage.
Thank you. And a second from Senator Baumgardner. Committee, you all have heard the motion. Is there any discussion? Not seeing any, then all those in favor of the motion signify by saying aye. Those opposed, same sign. The motion carries. We will next turn our attention to Senate Bill 458, specifying that certain drug offenses do not give rise to forfeiture under the Kansas Standard Asset Seizure and Forfeiture Act. And with that, a brief from the revisor.
All right. Thank you again, Madam Chair. Jason Thompson. SB 458 is the forfeiture bill that you heard on the 13th. This is the bill that contains all the recommendations from the 2023 Special Committee on Civil Asset Forfeiture that several of the members served on. I won't go through each of those items, but there were, I think, 8 different items from that are in the bill. And then it also contains a couple of additional provisions that committee recommended study and possible action by a standing committee on. One of those is transfers and federal adoptions of forfeitures. Another is the right to jury trial in forfeiture proceedings. And a third is related to proceeds and at least reporting what is happening with proceeds that are used or that are gained through forfeiture proceedings and reporting to the legislature on an annual basis. So those 3 additional provisions are also in the bill: federal adoptions, jury trial, and some reporting requirements for proceeds and financial transactions.
Thank you. Committee, any questions for the revisor? Not seeing any. And want to update committee. Last week, the House heard the House bill. There was an attempt by some of the opponents to amend the bill in committee, and the amendment did not succeed, and they successfully passed it out of committee. I would like to have a Senate position for a conference committee so that we can talk about some of the differences and see what's the best policy moving forward. So with that, is there any discussion on Senate Bill 458? Yes, Senator Baumgardner.
Thank you, Madam Chair. So does the House version differ significantly from our version?
There are 3 pieces that were discussed in the interim that was suggested a standing committee look at as well. And those 3 are in the Senate bill. They are not in the House bill. And the 3 are the claimant, if they want, the person who's had their property seized can request a jury trial, a jury of their peers. The second is a prohibition on federal referral. And the thought was that if you're referring it to federal asset forfeiture, then it's none of the reforms that we make here in Kansas would apply to that procedure for asset forfeiture. And the third piece is some different reporting requirements to make sure that the legislature is kept up to date on the number and amount of and the value of the seizures that are made, how many claimants contest the seizure, and there might be a few other pieces, but just to keep the legislature more informed. And maybe I should have had the revisor answer the question, but so those are the 3 main differences. Yes, and with that, any further discussion, or is there a motion? Yes, Senator Stephan.
I'd like to make the motion that we pass Senate Bill 458 favorably.
Thank you. And the second from Senator Olson. Committee, you all have heard the motion. Is there any discussion? Seeing none then, all those in favor of the motion signify by saying aye. Those opposed, same sign. The motion carries. Thank you, committee, for your attention to working some of the bills we have previously heard. And now we can turn our attention to our bill for today on our agenda. And it's rather lengthy, but we do have significant time left in committee. And with that, then, we will open the hearing on Senate Bill 491, standardizing criminal history record check, fingerprinting language, and defining who may be fingerprinted for a criminal history record check. And this is brought to us by the KBI. And with that, then, a bill brief from the reviser.
Thank you, Madam Chair. Good morning again, committee. Jason Thompson, Office of Reviser of Statutes. You have the fairly lengthy bill brief prepared by my colleague Natalie Scott, who also was the one who did most of the work on this bill. Substantial bill here, 211 pages, and we got the brief down to 7 for you. So hopefully I'll keep it even quicker than that. Essentially, the bill would enact 3 new sections of law that will replace the fingerprinting language found in all the statutes amended in this bill. That's the peanut of what the bill does. The memo and the bill, if you want to look through it specifically, breaks those out into 3 new sections and then puts each agency or entity that can do fingerprinting in the proper category for what information that they will continue to receive. The intent is not to change anything that's received, just to maintain what is received under current law, basically keeping those policy choices in place in this bill. So new section 1 is the fingerprinting requirements for criminal justice agencies. The ones that are in there are folks like the city clerk for position of chief of police and the county election officer for a candidate for sheriff and the governor when appointing the Kansas Highway Patrol superintendent, right? So these are law enforcement and criminal justice agencies. It's also the one that would contain the folks that go to the Commission on Peace Officer Standard and Training. So you're applying for law enforcement certification, you're covered under this new section 1. New section 2 is the section for fingerprinting requirements for governmental agencies that are not criminal justice agencies. And I won't go into each category there. You can see it goes on for a number of pages, but they're essentially broken down by what you get when you do your fingerprinting and your record check, what you get back. So the first one there, you get adult convictions, non-convictions, diversions, expunged records, juvenile adjudications, juvenile non-adjudications, juvenile diversions, and juvenile expunged records. And that goes to the Department for Children and Families, or KDADS, for participation in a program administered for the placement, safety, protection, or treatment of vulnerable children or adults. So for that particular position, if you're requesting fingerprints, what you get back is all of that criminal history record information. And as you go through those lists, each one of them has maybe a slightly different variation of what you get back. For example, there's a little bit less of juvenile that you get back from the state lottery or the Racing and Gaming Commission right below there. And then if you're applying to the AG for a concealed carry license, there's a little bit different information they get back that has its own subsection, and so on and so forth. All the way down into the folks that just get back adult convictions. So there's a whole subsection for folks that just get back adult conviction records and no other records. And that's the long list on page 4 onto page 5 of the memo. So you can see that that's a number of agencies and entities. And then the last new section is new section 3. This is the name-based criminal history record check for certain individuals. So there's certain information you get back about adult convictions and non-convictions, and certain information you get back about just adult convictions. And that's the last bits on page 6 of the brief. I will point out that each of the sections maintains that current law language about being able to charge reasonable fees for conducting these checks, and that when you receive this information, it has to be kept confidential. It can only be used for the specified purpose the statute gives you to use that information for. And if you disclose that information or break that confidentiality, it can be punished as a misdemeanor. It can also cost you your job, get you dismissed from your position in some cases. So those provisions are maintained as well in the new sections. And again, just to reiterate what I said at the beginning, sections 4 through 103, so all the amendatory sections, are just essentially striking fingerprinting language from those sections because it's replaced and replicated in a standardized form in section 1, 2, or 3, depending on what, the context that it needed. So that's the bill. 200 pages in a fairly short amount of time, I hope. And I'll be happy to answer questions or get out of the way for the KBI who really knows this bill. So.
Well, thank you, Jason. That was the Reader's Digest of 211 pages.
Very much.
So, and I'm glad you addressed the confidentiality, because I've had questions from others about the bill. Well, would the child care facility be able to see what came back with the background check, and would other entities? I'm not singling out them, but would the physical therapist office be able to look at that either? And you've answered that no. It would be a crime if they shared. Well, what is sent to the child care facility or the other facilities that are affected by this bill? Is it the entire report is provided to them or not?
Madam Chair, and I don't know exactly where child care facility would be in this bill. I'd have to go find them.
I just happened to open it, and that was the page that came up. So again, not picking on our child care facilities,
Sure.
just the first example that came up.
So depending on which subsection they're under, they would request the information through the KBI, and that the history record check would come back, and they would receive only the information the statute allows them to receive. So that might include only adult convictions. It might include adult diversions. It might include juvenile adjudications, or it might not. So it depends on which section you're in, and that tells you what information you get back. And then the person who is in, if it's a licensing issue, the entity that does the licensing would receive the information, and they have to keep it confidential, and they can only use it for the purpose of licensing. Any other disclosure of that is prohibited. If it's for employment, the person who's doing the hiring receives the report, considers it in whether to hire you or not, and that's the only thing they can use it for. They can't disclose it otherwise. So that's kind of the big picture. And if we want to talk about any specific ones, or if KBI has more to add, I'm happy to have them clarify how it works in the real world. But the statute's pretty clear that you request through this standardized process under your particular subsection of section 1, 2, or 3, depending on where your agency is or your public entity is. And then you get back only what the KBI is authorized to give you by statute, and you're only allowed to use it for the purposes provided in your statute. And if you break that confidentiality, you can be punished both criminally and potentially through employment actions. So.
Thank you. Committee, any other questions? Senator Steffen.
This is a tough one now. Without you looking, what exact page and line do new sections 2 and 3 start on?
Oh,
you can look.
I know. So new section 1 is there on page 1 of the bill. New section 2 begins, and I looked through this when Natalie and I were doing the bill brief, but that was, over the weekend. So new section 2 is on page 2, line 28. And new section 3 is on page 8, line 26. And then the amendatory sections begin on the top of page 10. So it's really the first 9 pages of the bill that are the new sections. And then you'll see on page 10, you start to get amendatory sections where we go in and we strike provisions relating to fingerprinting, or we define applicant because that's a word that's used in the fingerprinting statute and tells you who can be fingerprinted. So that's where the amendatory language starts from page 10 on to 211.
Thank you. Committee, other questions? Not seeing any, then thank you, Jason. Appreciate it. And we will invite our first proponent conferee to the podium, Robert Jacobs, Associate Director, Kansas Bureau of Investigation. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. My name is Robert Jacobs, and I currently serve as the Associate Director at the Kansas Bureau of Investigation. We appreciate the opportunity to come and provide proponent testimony on Senate Bill 491 today. Jason did a great job of explaining the bill. It is a complex bill. Since he did not go over the 103 sections of the bill, I won't either. So what I thought I would do is, you have our written testimony, and rather than dive into that, which you can read, I thought I would really tell you the catalyst of why we have this bill in front of you today and how that started. So KBI is, as you know, we are authorized through statute to maintain the criminal record repository for the state of Kansas. Those include arrests and convictions that occur in Kansas, and we maintain those through our statutory requirement. Additionally, the legislature has authorized various entities, which can be such as Department of Children and Family Services, Board of Nursing, Department of Education, Board of Healing Arts, just to name a few. There's about 55 different statutes that authorize the KBI to release criminal record information to those entities in order for them to hire, to license, and to certify individuals who are applying for certain positions within the state. And these positions range anywhere from dealing with vulnerable populations to our financial industry. So we are authorized to give those upon their request to those entities. It is important for us when we're looking at providing that information to not just provide criminal behavior that occurs in Kansas, but also outside of Kansas. So in order to do that, we access Federal Bureau of Investigation records that take in criminal behavior and criminal records from the other 50 states or the other remaining states outside of Kansas. So, and we provide that as well as the records from Kansas to these entities that are requesting it. Well, really what this comes down to is about 2 years ago, we started to see a pattern of behavior or pattern of occurrence when we were requesting access or authority to provide a certain entity the national criminal history records from the FBI. That process, and I want to explain it real quickly as to how it works, because it might provide a little background on why we're here. So when a bill is passed, after the session ends, the bill is passed into law. The KBI takes that statutory language and we send it to the FBI to see if they will authorize or approve us to provide that national criminal history record information to that entity. Unfortunately, that review process takes over 12 months to occur. So if they then come back and say, no, that language is not approved or it doesn't meet their requirements, we then have to follow up the next session to amend the language in statute to fix that and allow them to get those national record checks done. Well, what we started to see was they were changing those requirements pretty frequently. What might have been approved this year might not be approved next year. And what we would have to do is go back and change that language. Unfortunately, we started to see in other parts of the country, not here necessarily, where the FBI started to say, well, now we're going to look at your old language and not authorize you to have it for all these other statutes that you had done in the past. Even though it was approved at the time, it doesn't meet current requirements. So this bill was brought forth. We started working on this last year to bring forth a bill that would rearrange or reorganize the statutes that deal with criminal history record checks, where we would have these 55 different statutes all refer to a single statute. So if the FBI or anyone else decides that we need to change language in the future, we have to change 1, 2, or 3 statutes as opposed to 55 different ones, which is kind of where we're at right now. We have noticed that the FBI has started to prohibit allowing other states to do that on past statutes that they've previously authorized. And so this is really a preventive bill to try and avoid that in the future. We also obviously are trying to reorganize our own statutes to make it more efficient for the revisers and for the legislature. Finally, I just want to say this is a pretty complex bill. We recognize that. We worked with our stakeholders, these other entities across the state agencies who need or whose statutes authorize them to have these criminal history records. We worked with them to try and get the language correct, and we recognize that it is a complex bill and we may have missed some things. So you will hear some friendly amendments offered in other testimony, and we encourage you to support those friendly amendments. We think that what we're ultimately trying to do is get as close to the mark as we've tried, as we need to, and to bring the statutes, to amend the language in the statutes up to what the FBI currently requires, and we hope that you will support this bill. With that, I would be happy to stand for questions.
Thank you. Committee, while we have Mr. Jacobs at the podium, let's go ahead and entertain any questions that you might have for him. I would like from research, if we could, or Robert, if maybe you have it in your back pocket. You said the bill addresses 55 statutes, and I see they're listed here on page 1 of the bill. But could we get, maybe it would be helpful for the committee, the list of agencies that are impacted by this? If we heard, I think, did you say the Board of Healing Arts as
Healing
well?
Arts is one. I believe Board of Pharmacy. I don't know all 55. I apologize, but
Sure.
we certainly EMS is another one. KDADS. When we talk about foster care licensing, people who are going to do foster care. There's a whole range, and what we've talked about is civil fingerprint checks. There's also name-based checks. The Banking Commission does backgrounds for their folks who have access to a significant amount of money and finances. The lottery, racing and gaming, all of these different agencies utilize civil fingerprint background checks.
Thank you. And yeah, if we could just have a list from research, that would be helpful, I think, all the entities that are impacted in the bill. Yes, Senator Gossage.
Thank you, Madam Chair. As I was reading through the neutral testimonies, it seems like there are a couple of little cleanups that would be helpful to the Department of Insurance and to the Board of Pharmacy. Have you had an opportunity to see those at all?
Yes, ma'am. I have seen the ones for the Board of Pharmacy. I spoke with their executive director a little bit ago. I haven't seen insurance, but I did see the emergency medical services, and we're in favor of these amendments. We don't see a need to. Again, we tried to cover as much as we could, and there's a lot of moving parts to this bill. So if it is a friendly amendment, we would encourage you to accept that. There are some things that we need to change. One of the big issues, and Jason mentioned this in his brief, that the FBI was really concerned with was definition of what an applicant is, definition of what a director is. So in statute, they really wanted us to define that. And that is really what Natalie and our folks and the rest of the entities have been working on for the last 2 years.
Good. And I do see that with the Board of Pharmacy, they were just saying if you just say somebody is a licensee, then they couldn't work with an applicant because they're already licensed. So that goes along with what you were saying about definitions. And I think that could be helpful to them. And again, when you've got a bill this large, it's good to know when you've got people weighing in that are paying attention to their part. Then also I noticed with the Department of Insurance, it's just a matter of who's going to pay. That part was stricken.
Yeah.
So I appreciate the fact that you've already looked at these and consider those friendly. Thank you. Thank you, Madam Chair.
May I add one piece to that? And I do appreciate the question. The only thing I would say is I understand that there may be a request to just add a title in there, licensee versus applicant, whatever it may be. But again, to some degree, this is out of our control as to what the FBI will allow. And so we're happy to make whatever amendments that they choose, but realize that if the FBI doesn't like that, we may have to come back and change it next year.
Thank you. Committee, other questions? Not seeing any, but stand by, Mr. Jacobs, excuse me, because there may be some more.
I will be right over here. Thank you
Appreciate
very
that.
much.
After our next proponent conferee, Joseph House, Associate Director, Kansas Board of Emergency Medical Services. Please introduce yourself and welcome to committee.
Good morning. Thank you, Madam Chair. My name is Joseph House. I'm the Executive Director of the Kansas Emergency Medical Services Board. We stand in strong support of Senate Bill 491 and appreciate the work and effort done by the Kansas Bureau of Investigation to clarify this language and make it a whole lot easier for not only them, but for us as well. So Kansas is a state of the EMS, or is one state within the EMS compact, and all this is not necessarily specifically addressed within our testimony. We are encountering the same situation in other states as well, as similar language is coming across. It's been approved in one state, but not necessarily in the other. And so this approach is tremendous. Great work on their part on getting that through. With that, it is a very complex bill, and we were one of the agencies, so we believe there was a slight oversight on. So we are in currently subsection B7 of new section 2. And that gives us records of adult convictions and non-convictions. Our existing law within 656129 gives us adult convictions, non-convictions, and then also adjudications. So that is actually more appropriately addressed within subsection B5. And so no policy change. We do believe that we should be one of the agencies moved over into subsection B5. So that we can continue to receive the results of those adjudications. We do license individuals that are under the age of 18. And so you can be 17, gain a license to practice as an EMS provider. With that, we do believe it's been appropriate for us to receive also records of any type of juvenile action whatsoever. And so I appreciate that there wasn't supposed to be a policy change with this, but we would request that we actually be moved to subsection B3 within that new section 2. That would give us access to receive those records and results for all juvenile actions taken. And again, the EMS population, our EMS providers are taking care of individuals when they're vulnerable, we could be taking care of minors without a parent or guardian present. It warrants a very high degree of trust from the public, and we feel as though being within subsection B3 would grant us the authority to meet that section. So I'm happy to answer any questions that may arise at the appropriate time.
Thank you. Committee, any questions? We'll go ahead and take questions at this point since we had questions for our other proponent conferee. So any questions? Not seeing any. We do have, thank you. We do have proponent written only testimony in your committee documents from Jennifer Caswell, PT, DPT, APTA, Kansas Chapter Legislative Chair. And I'm, the physical therapist, I don't have the documents in front of me, but I think that's who they are. Yes, the American Physical Therapy Association. So with that then, do we have any neutral conferees? We do. We have, we will first hear from Alexandra Blasi, Kansas Board of Pharmacy. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. I'm Alexandra Blasi. I'm the Executive Director for the Kansas State Board of Pharmacy. Very briefly, because I think Senator Gossage understood my testimony here, we greatly appreciate and I would consider us neutral and supportive of the KBI moving this bill forward, and appreciate this committee's attention to an important issue that needs to be addressed in Kansas. We appreciate the opportunity to work with KBI on the bill draft. There was just simply an oversight in the language in our authorizing statute. That word person, which we understand that's too broad and vague, was struck, and the word licensee was inserted. We currently have authority to fingerprint, of course, our applicants as well as our licensees. And so I've made a suggestion for an amendment there, but of course would defer to the revisor's office on the most appropriate way to capture that information should the committee deem it appropriate. And really appreciate the opportunity to work with Robert and his staff at the KBI to get this all managed out with all the different sections and provide feedback on that. With that, I'd be happy to stand for questions.
Thank you. Committee, any questions? Not seeing any. Thank you. Do we have any other persons wishing, let me go back for a second, to testify as a proponent? None. Okay. And do we have any other neutral conferees wishing to testify? Yes, we have Eric Turek, and you are on the list. Sorry about that, Eric. Eric Turek, Director of Government and Public Affairs, Kansas Insurance Department, testifying as a neutral. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Members of the committee, Eric Turek from the Kansas Insurance Department. I'm the Director of Government and Public Affairs, and we do appreciate the opportunity to provide neutral testimony on this bill. We do appreciate and sincerely appreciate the effort and work that's gone into this bill from the KBI. We do understand the need to streamline these statutes, but we do have some concerns. I do want to reiterate to the committee that the department does conduct background checks and fingerprinting on all resident insurance agents and public adjusters that we license. In 2023, we conducted about 2,693 of those. And we do wish to preserve the existing authority that we have in statute. One concern that we do have is in new section 2B7, that is page 6. Under current law, the commissioner has access to the record of criminal arrests and convictions, and our concern is similar to the Board of EMS. We have been moved to a different section that would only grant us access to records of adult convictions, and so we just seek that parity there with what's in current law. The second concern we have is in regards to new section 2B8, item X. That's just a duplicative section that's already on page 5. And then finally, under existing law, the costs of fingerprinting applicants for insurance agents and public adjusters, the current law says that whenever the commissioner requires fingerprinting or a background check, both, any associated costs shall be paid for by the applicant. That language has been stricken on pages 69 and 72. It does present a little bit of ambiguity if the department even has the authority to charge those costs. So those are our three concerns, and we have had talks with the KBI just last week on these concerns. We believe that these are just minor changes that can be presented in the form of a balloon amendment, and happy to stand for questions.
Thank you. Committee, any questions? Senator Wilborn.
Thank you, Madam Chair. Thank you, Mr. Turek, for your testimony. And I'm going to ask you a global question. This applies to all the conferees. I assume that you have been working with revisers to get those amendments prepared, because we're getting short on time and we'll want to work that bill. So I hope everybody's got that covered. So when we'll work the bill tomorrow. Thank you.
Thank you. Committee, any other questions? Not seeing any. Then thank you, Mr. Turek. Appreciate it. And any other neutral conferees wishing to testify? Not seeing any. Any opponents? Seeing none. Then thank you to the conferees for your appearance and testimony, and we will close the hearing on Senate Bill 491. Committee, we do not have any bills scheduled to be heard tomorrow, but we will be working some of the bills that we have heard before. So please be prepared with any amendments that you may have. And with that, then we're done with our business early. So appreciate that and appreciate your attention. We might be staying until noon tomorrow. It is our last day to work bills and get them out of committee. So appreciate your time till noon tomorrow if necessary. Thank you. And